All right, well, I wanted to welcome everybody. Thanks for coming out to talk with us and to share your stories while we talk about the nuts and bolts of candidate nomination papers and challenges to candidates' nomination papers and defending against those challenges, which is the bulk of what we're talking about today. So there's lots of other aspects of being a candidate and running a campaign, like raising money and all that. That's not what we're here to talk about. We are basically going to walk through the process of the candidate nomination papers and what might happen in the challenge, which we know they're oftentimes inevitable that candidate nomination papers are challenged. But I thought I'd also start, how many of you know CAC? All right, so all of you seem to know about CAC. So quickly, just to remind you, our mission is to build democracy in the 21st century. We're a nonprofit, nonpartisan, community-based, grassroots legal organization. And in addition to doing civic education work, we also do public policy, advocacy. We do client work where clients are trying to access the government decision-making process and put their 2 cents worth in the process and participate in that process. When they reach barriers in participation, they'll contact us so that we can assist them in navigating to get their voice heard on issues that they care about in their communities. And we also do litigation and administrative appeals to the PAC's office, which is the Public Access Counselor's office at the Attorney General's office, an arbiter for the Freedom of Information Act and the Open Meetings Act when there are disputes about violations that the both bodies are accused of violating the Freedom of Information Act or an Open Meetings Act, the situation. So without further ado, I think what we'll do is we'll get started because we have precious little time. There's a lot to cover.
And I'm Andrea Alverez, and I'm a community lawyer with Citizen Advocacy Center. And I just want to make sure that I give this disclaimer at the beginning, and it's on the paperwork, and I'll probably say it again to Maryam. Well, all information tonight is purely educational and should not be taken as legal advice. There are variations to the information, and you should consult with legal counsel for specific election matters or other election matters. My cards are at the back if you want to take a card if you have specific questions about your situation and want to contact me or Maryam at another date and time, and we can set up time to talk to you. How many people here are circulating petitions currently since September 23rd was the first day to pick up petitions for the April 7th election, okay? How many people have been through a ballot challenge before? Anyone? One person? Okay. 2 people. Okay, so please feel free to add to the conversation as we go through since you have firsthand experience with this. I want to go over the important dates just really quickly. September 23rd, first day to circulate your nomination papers, and then dates to file December 15th through the 22nd. And this must contain original sheets signed by the voters and your circulators. And December 30th, right before New Year's Eve and that awkward weekend we have between the holiday and New Year this year, is the last day for filing objections to the nominating petitions. And then January 5th, 2015, which I believe is actually a Monday, is the last day for filing petitions for referenda for submissions of questions of public policy. And then January 12th is the last day to file broader referenda questions that aren't local. And then January 20th is the last day for a governing body to adopt a resolution for a binding public question. And we'll talk about that a little bit later. So briefly, eligibility to run for office. Generally, there's a 1-year residency requirement in the district. And make sure if you're running for a school board, library district, your districts are not always coterminous with your municipality. There's townships that exist. They also have different districts. A person is ineligible to run for office if at the time they are required to take oath, they're in tax arrears or other payment arrears, so make sure all of that is squared away. And if they have been convicted of an infamous crime, bribery, perjury, or another felony. So if you have any of those, ineligible to run for office. When your nominating papers are filed between the 15th and the 22nd, you need to file a statement of candidacy, a statement of your economic interests, the original signature sheets, no copies of signature sheets, a loyalty oath is optional, and then your nominating petition sheets. Nominating petition sheets. And who may sign your signature sheets? These are the sheets we'll probably talk about in a lot of detail. A voter registered in the subdivision for which you are running for office. And a great way, and the Cook County Board of Elections and Cook County Election Commission has a very easy online system that you can go to and look up every signature on there, and you can look up people by address to make sure they're actually a registered voter. So for a lot of these elections at the local level, you only need 50 signatures. We recommend getting more than that, but you can take the time to go look up each signature to make sure it's a registered voter, and we do recommend doing that. So a signature guideline, I was speaking with someone last night where people were printing their names. Make sure people are signing the signature. If they say to you, how do I do this? Like you did when you signed your election card, people's signature changes. Now we have the 17-year-olds who registered to vote in school, and this may be their first year voting, and being able to sign petition sheets, and sometimes they're a little confused about it, so talk to them about that. Standard abbreviations for a residence address may be used, so a NOR can be used, street, ST, avenue, ABE. Signature, again, if you signed your name John and your name's Jonathan, sign like you signed on your petition. Don't sign Jonathan if you sign John. Pencil and blue ink signatures are allowed, but a lot of times that may be something that causes a challenge, so try to make sure that you are circulating with a black ink pen, and if you have circulators, they're also using a black ink pen. Only a circulator with the sheet can strike a name on the sheet, but an individual can also submit a written request with the local election authority to have his or her signature removed. The candidate can also strike the signature. A voter cannot sign for anyone else. Yeah?
Can you give reasons why you want to strike a signature?
If you look it up on the website to see if they're a registered voter and they're not a registered voter, and that's taking up a spot on your signature and you're not going to get to your nominating sheet requirements, or if you see it's a printed signature instead of a signed signature, so you don't have to go through the challenge to that signature, you know the address is incorrect. Those are some of the reasons you may want to strike the signature. Yes.
Would you strike it? Would you initial it or anything? Or
no, you strike it.
the circulator or the candidate?
So if you have, say you said you need 50, say you have 200, and you notice that there's 10 throughout that 200 that are printed, you don't need to strike those.
There's 10 that the circulator did it?
Do you need to strike them if you have 4 times the signatures you need and you have some of them that are printed? Is it really a big deal to strike them, or you're saying you're opening yourself up to a challenge just because you have some that are
It
printed?
depends on what's going on in each individual town, and if you're likely to be open to a challenge, that may be something where someone still goes ahead and challenges it, even though you're 200 over. It could give opposition or someone reason to question the validity of the signatures. We were partners in a recent ballot petition signature challenge, and almost every signature was challenged.
Well, also there might be the situation where for some elections you can only get so many signatures and you can't exceed, or like any signatures beyond a certain threshold just won't be considered toward your signature, your total sheets. So if you know that you have a whole bunch of invalid signatures, by striking them as a circulator, then you give yourself more room to get ballot signatures. So that's probably a rare case, but that might happen.
It may be better to err on the side of caution.
You can take your petition back to the circulator, and they strike it?
Only a circulator can strike a signature, because the circulator is the one.
How do
They
you know?
strike it.
Okay.
Because, and then they take it to a notary public. So notary public signs the bottom of the signature. the sheets.
Because there's circulators making it out basically with their signature, that they witnessed the signatures and it's all valid, and then the notary public notarizes that oath.
So when your signature sheets, depending how many signatures they are on them, I recommend after you have it signed, going home, checking every single person on that list.
If a signature is challenged and the challenge is upheld, does the whole petition get thrown?
We'll get to that later, but the answer is yes.
So if they should be checked and struck before it's taken to the notary?
I would check and strike it when the circulator still has it before it's taken to the notary.
Okay. And it's the circulator and not the candidate that can
It's the
strike?
circulator.
Just the circulator. Okay, thank you.
So who can circulate? This is actually a very broad range of people. A citizen of the United States who is over the age of 18. And the person must witness personally in their sight and confirm that the signatures were done in front of them. And then after the sheets are done, they can go to a notary public. There's notary publics at banks, libraries, usually there's one in our office. And they will sign that the person is attesting that the signatures were done in front of them. I know I can sign my husband's name really well, but I couldn't sign it on there because it would be a bad signature, and a lot of people have signatures challenged because they'll say, hang on, I can sign my kids off at U of I, but I know they'd sign this. Don't let people do that. That causes an invalid signature. You can only sign for yourself and in the presence of the circulator. And that brings us to the idea of paid circulators. I think in more local municipal elections, there isn't as great of a need for it because the signature threshold requirement is lower. Paid signatures can be very controversial. It can be depending if they're getting paid hourly or if they're getting paid by the signature, but the accuracy rate tends to be a lot lower on whether they're valid signatures. So be cautious with that. Yes?
We happened to stop in and get a sandwich at a bar in Brookfield, and somebody was circulating petitions in a bar. That's not legal, is it? Anywhere where alcohol is present, or no?
I haven't heard of that before. Do you? Because I know they circulate petitions at
I've seen petitions being circulated at bars.
concerts.
Okay.
Yeah, so I don't think it's illegal, no.
Okay.
No restrictions.
No
I mean, I
restriction.
guess it depends on the establishment and their rules. So the policy of the establishment. So, a government official can't circulate petitions while he or she's working at their government job, for example, at their government job.
At a city council meeting.
That probably
Can't
wouldn't be a good
doing
idea.
that.
So it depends on the context and the situation and the policies.
And with that, a lot of people say they're registered voters. That doesn't necessarily mean they are registered voters. We don't often like telling people, especially if it's a neighbor or a friend or at church, if you're not a registered voter, when someone asks you to sign a petition. So again, check those signatures. Yeah.
Is that easy to find on the
Excuse me?
notary site?
What's
or
the
what?
website?
The website is cookcountyclerk.com/elections/2015 elections. And the Cook County website, cookcountyclerk.com. If you go to www.cookcountyclerk.com/elections, a lot of information will come up. And the Cook County Clerk's office is one of the best offices in the state with providing information and being accessible for questions. And there's suburban locations and a city location. So there are a lot of suburban locations.
I think her question, I'm not sure if you meant signatures or you meant addresses.
I didn't hear you.
It's easy to work with them to get the list of voters and addresses and registered voters. Was it specific to the signature?
I think it was, no, it was with addresses too.
I'm not sure is there any way without going down to the election board to actually be able to visually see?
The signature.
Yes.
I think you would have to go in person or you can pull way up.
the address on the county clerk. Yeah. But you can't check the signature after to see if the signatures match. And yeah.
Unless you're the person that's.
You can only see their address and their registration, but you can't necessarily check to see if the signature matches, or chances are they will match unless the circulator is allowing people to sign for others, which is a no-no. So the husband should not be signing for a wife. Oh, my husband would have loved to sign this, but he's at work. Let me sign for him. That kind of a thing. So, in the absence of that kind of thing, or the person doesn't understand that they need to sign on the candidate's petition signature sheets, that they need to sign in the same way that they signed their voter registration, well, their card, when they first registered to vote.
And I want to make a special note for school board candidates in Cook County. School board candidates in Cook County need to file their petitions and their nominating papers and their statement of candidacy and all of their papers at the Cook County clerk's office. And this can be done at a suburban location. It's not filed with the municipality. And this is, I believe, a change from previous times. So make sure that that is noted if you know anyone running for a school board in Cook County. It needs to be filed with the clerk's office. And they will have the times that it can be filed, posted around late November, and the locations of the clerk's office, the sites, dates, and times. So that is very important, but you still need to file your statement of candidacy, your receipt for the filing, statement of economic interest, a loyalty oath, as I was known, and your nominating signatures. So, as we said, petition sheets must not be circulated more than 90 days preceding the last day of filing the petition. We're within that time period right now. A circulator statement on a candidate's petition, so the bottom is usually where the circulator statement is, must specify the dates, either the dates on which the sheets were circulated, the first and last dates on which the sheets were circulated, or that none of the signatures were signed more than 90 days preceding the last day of filing. So it's very important that that statement is on there. And at the bottom, the petition circulator must complete and sign the statement at the bottom, certifying that the signatures on the sheet were signed in his presence, are genuine, and to the best of his knowledge, the person was a duly registered voter, resides in the address they said, and the statement has to be sworn and signed before a notary, and there also has to be that statement on there. The petition circulators also need to put on there their residence, their address, written or printed, including the street address, and their city, village, and town. I recently had a situation last, I think it was fall, where there was an issue with a notary had switched where they had lived and hadn't registered properly. So make sure your notary's registration is up to date, and you ask them, I think they have to re-register every few years, because I also saw some of those petitions get thrown out because the notary wasn't registered. So that's just something to be aware of. And their stamp should say on there that it was.
You can check the registration of notary online at the AP's, I think it's the general website.
So once a petition is filed, you can't have any changes. Only a circulator can strike, and a voter cannot sign for anyone else. After that, I think maybe challenges we'll talk about now.
Well, are there any questions about, I guess, nomination papers and signature sheets prior to getting into challenges to signatures and challenges to the nomination papers?
So if you notice someone printed instead of signed, you strike it through, you go back to the person who had to sign it.
That's
okay.
Okay. Your statement of economic interest, I should mention.
I have one more question.
Yeah.
I've seen petitions where, rather than writing the town like Forest Park, Illinois, they use ditto marks. But when I was an observer to the process down at the Board of Elections one time. That was kind of a controversial thing, whether or not they accept the ditto marks or not. So do you have a recommendation?
I would recommend, if it's all in one town where you know everyone's going to be living in Forest Park, Forest Park, Forest Park, cook, you can pre-fill those out. And you can have it typed, I would recommend. I've seen petitions like that where it says all Forest Park, all Cook, all Illinois is not always on there, but you can have that pre-populated so you don't run into that problem. And I would do that typed and printed. That can be complicated if you're in districts like the Proviso School District, which would take into account more than just Forest Park. And you would have to have all
What if someone starts to fill it out, print it, you go, oh, we got to sign it, and they quickly cross that out and then sign it?
I would cross-strike that and have them fill out another line to be on the safe side.
Okay.
And that's erring on the side of caution, admittedly. For your economic interest statement, the receipt for the filing of an economic interest statement may be filed no later than 5 p.m. on the last day of the filing period. So that would be on December 22nd, but you do need to file that by December 22nd, so you can file your paperwork and bring in your receipt. The statement of candidacy has to be with the nominating papers. Your name on the petition has to be your legal name. It can't be Joe, Doc, what are some other ones we've seen?
Well, it can't, people can't use kind of like titles, the king,
Doctor,
doctor, yes, another one, doctor.
Mr. even, it
Or
has to be your
reverend.
legal name.
Yeah, those are titles and you're not allowed to use those.
No political slogans in your statement. And you must swear to and sign the statement of candidacy, and that has to also be notarized, yes.
Doesn't have to be your quote-unquote legal name.
If you have a nickname
Richard,
like
you go by
Joe.
Rich.
You can have that in quotations, Richard, Rich, names.
But if you commonly go by, and all of your mail even comes as, I don't say, for instance, your name is Christopher, and you go as Chris all the time.
Yeah, I think the rule is if that's your common name and everyone knows you by that name, that
It may be used
that
in
name.
addition.
Yeah, but I think you still need to have the in quotations since it's not your given name.
It may be used in addition, as, yeah.
Sure
Is
about
the
that.
rec-
So it would show up on the ballot like that.
Yeah, it does.
You're talking to a teacher who taught Palmer method, but I also received 9 graduation thank you notes, many from college graduates recently. None of them used a cursive sign. I wonder what some of these signatures are going to look like. Who is going to question the signatures? Someone my age or someone your age? And I'm sincere about that because of the fact that the signatures today, some of the letters are not connected one to the other. What indicates a signature rather than a printed form?
So the signature can be a printed form if that's what they put on their election, signing their paperwork.
Okay.
And the person determining if the signature is valid will be down in Cook County at the clerk's office, and will be looking at the card and comparing the card. There's these big binders with signatures in them. You may have seen them. And they'll be looking at your sheet and that, so it needs to match.
So what Andrea means to
It can't be
say is
printed.
that during the time period after a candidate submits their nomination papers and their signature sheets, during that time period, should someone object, they're going to go down in order to place a proper objection. And the objection has to be specific and explain why they believe signatures are invalid, for example, among other objections that an objector can make. And the way that they recognize what features of what signatures they need to indicate is by going to the clerk's office and checking the registration rolls.
That seems
So,
reasonable.
yeah. So So, you know, they're the quibble, but I know that even though someone might sign, like, print a signature, and let's say their registration roll is a little bit more cursive or something like that, I know that through handwriting analysis, if some candidate had the means to do that they could perhaps rehabilitate a signature through handwriting analysis if it came to that. But generally speaking, to avoid those kinds of objections, just try to not get printed signatures unless that person swears that their voter registration card, that's the way they signed it.
Thank you.
I may be out of order in the sense of when I talked about this, you may have already, or maybe right now, but a question about your handing in the signatures. And if you are running in a village election, and that is the place you turn them in, is it that municipality or is it that village that then determines and has the authority on judging the signatures, et cetera?
That is a perfect segue into filing objection petitions if there are no other questions. So nomination papers are deemed to be valid unless objections are filed in writing within 5 business days after the last day for filing nomination period. The nomination period is so December 27th, I don't know if that's a weekend, the 22nd is the last day, so 5 business days after that. And a person who is an objector can be anyone in the community, and they'll go in and they'll look at your sheets, and the sheets are open to everyone.
I think they have to be a registered
voter. And they're going to be the ones who say, this signature doesn't look good, this signature doesn't look good, this entire sheet is round robin where, you know, it looks like people just went in a circle and did it.
We'll talk a little bit about the different objections.
Okay.
So earlier, Andrea was presenting information about the nomination papers from the perspective of the candidate, but from the perspective of the objector, an objector might object to the content of the circulator's affidavit. So Andrea mentioned all of these very important features of the circulator's affidavit's content, which includes the U.S. citizen stating that they're a U.S. citizen, the time period for the circulation, et cetera. But they haven't collected signatures in the time preceding 90 days prior to the election. And she talked a little bit about proper notarization. So those are features that an objector might object to if there's some basis that they can articulate in the objector papers that there's a problem there. If for some, in small communities, if a voter like that circulator did not collect signatures in their presence, but let the nomination papers and signature papers kind of float around the room, and that person's not paying any attention, just keep signing it, and they're not actually there watching, that's a problem. So if someone has that knowledge and can articulate a basis for believing that that signatures were not signed in the circulator's presence, that they may object for that reason. The circulator has to sign their affidavit at the bottom of each page before the notary, in front of the notary. So they can't sign it and then later on a notary notarize it. That could be a basis for an objection. There's many different features of the nomination papers that can be objected to if you don't adhere to them. So, for example, the signature sheets need to be paginated chronologically, 1, 2, 3, 4, 5. They all have to be of uniform shape and have uniform content. So your signature sheets need to all be Xerox basically from the same template and not differ from one another.
We had a question where there was like a grayscale on some of them recently. Make sure you're printing the sheets that they're all the same look because you don't want to run into any problems.
Right, so that they all look like similar sheets in appearance prior to the signatures. It's always important you have to file original signature sheets, but for your own files, it's always really good to keep a record of the copies of the signature sheets that you collect. So make your own photocopies for your record, but the originals must be the ones that are submitted as part of your nomination papers. We kind of glossed over some of the different pieces of paperwork that are part of the nomination papers. So, for example, the statement of candidacy needs to be signed by the candidate. And so if the candidate fails to sign that statement, that's a problem. We talked about improper ballot names, which includes slogans as well as honorifics or titles. And let's move to the signature sheets. Because are there any questions about the nominating papers? If there aren't, let's use the bulk of the time talking about signatures.
Quickly, not later than noon on the second business day after the receipt of the objector's petition. So 2 business days later, business day and a half, by noon of the second business day, the person who filed the papers will find out there's objections. So you will know.
So yeah, the law requires that as soon as objecting
papers are
filed, that brings into resurrection the ad hoc local electoral board that is the arbiter of challenges to nominating papers as well as petitions for referendum. And
you'll be notified by registered mail or personal delivery that's received by the second business day at noon that there's an objection.
Right, because the local electoral board is comprised at the municipal level. There's municipal electoral boards. At the school district level, there are school district electoral boards. At the township, there are township electoral boards. And then we also have a state electoral board. And in each case, well, not in the state case, but in the other cases, it's always the head of the governing body that sits on that electoral board, the clerk of the governing body, and then also the longest sitting member on that board.
So you have a commission form during Forest Parks of the mayor, the clerk, and then whoever's been on the board the longest time would be the 3 people who comprise the electoral board who will be reviewing the challenges.
In the municipality, for municipal elections.
But not if they're candidates.
If they're a candidate, they're going to be checking signatures and they're running for office.
It's
Right.
the same office.
So the only recusal mechanism that exists in the law is precisely the one that you just mentioned, which is if a person who's before the electoral board is running for an office that an electoral board member holds, then that's the case in which the electoral board members must recuse themselves. But there's no other requirements for recusal, even though there might be other conflicts of interest that you might identify. Yes.
Just let me get a further clarification. The challenges that we had in 2011, the longest the mayor sat there, the challenges were for commissioners, the clerk was there. The longest serving board member was not there. They had a impartial arbitrator come in. He was the longest serving member was up for re-election. Was he not there because he couldn't be there, or
I don't know.
He was a candidate for the same office that were being objected to,
Right.
the same position. So they
Yeah, so if one of the electoral board members holds a position that the nomination papers are being objected to before them, that's a direct conflict of interest.
So they should be recusing themselves.
They should be, or they?
No, the law states
They
that they
will.
will. They should, like, they have to recuse themselves, and that's the only recusal situation that's identified.
And since you vote at large for your city council, any person, I don't know who the longest standing member is, if they're up for re-election on that level, would not be.
Are you going to get into the appeal process if you lose at the municipal level, what your next step is? Okay.
Yeah.
We're going to go
Let's talk a
through
little bit more about the signatures. Do you want to talk a little bit more about signature objections to signatures and like common objections?
The question I had earlier that it also relates is that does the municipal government and the board, do they have the signature sheets available to them?
They can go in person and go look at the signature sheets.
I mean, people.
The local
They're not
electoral.
down at the election board. They affect every municipality.
So none of the local electoral board members may object to any nominating papers. Is that what you're asking?
No, I know from experience that in the downtown,
Right.
and you can that information is available in the signatures if you go through a certain process to get them. In the municipality, are they available there?
The signatures?
the
Clerk, you have to go.
So they're.
You're going to you get copies and you go to the county.
Okay.
So if you were going to object, you would get copies of the petition and then go check the signature rules.
So
Yeah, because once the petitions are filed, they're available for inspection for 5 days. So anyone who's eligible to object can go over there and make their notes, and then they go home, and then there's all these requirements for objectors too, and like what they have to file and what they have to swear to, and they submit that to the clerk, and then that sets off this timeline where the candidate has to be identified by noon of the next business day, I think, or the second business day, which you were just in the middle of.
Yeah, the second business day.
And then I think that then the hearing has to be held, how many days beyond that? Notice of the hearing has to be given.
Within 24 hours after receipt of the objector's petition, the chairman of the electoral board will send certified mail to members of the electoral board, the objector and the candidate, and also the sheriff of the counties to serve a copy. And then they should convene not less than 3, no more than 5 days after the receipt of the objector's petition by the chairman of the electoral board. So it's a very short timeline that is playing out right there. And that's all happening between December 27th-ish and May. So it'll be happening, it would be happening very quickly.
Does that answer your question?
I was trying to understand the process of how one would make a judgment, depending on what the objection was. If there's an objection to signature, how would one go to verify the signature? It seems to be the only place to go is the election.
So we're going to, I think if we talk about signature issues, some of the issues, that'll probably answer the question. But what happens?
Where do you go to check the signature?
Signature.
So the
So you
place
go
that
to
you
the
go, you
clerk.
have to go to the election authority and check the signature.
And then at this hearing, they'll have the signature there, and we'll go through and compare. We'll have a discussion about whether.
I mean, the candidate who's defending their signatures will obviously want to do some prep work. So they're not going to want to rely on showing up to the hearing last minute and relying on those records. So chances are they'll want to go and check to their game plan to how they're going to defend against the objections.
I apologize. Those signatures are really only available downtown in the election, correct? They're not available in the true signatures, the copy of the signature, the sheets that any judge would have before an election. Those are only available downtown. They're not in the municipality.
They're not in the municipality.
Okay.
I don't believe.
I think I understand.
Yeah, it's at the election authority.
Correct.
So you can't, most likely.
We're talking about multiple authorities in the sense that one authority is the group that that the petitions are presented to you. And that could be.
That's the electoral board.
Yes.
So yeah, the terms here are the real terms that you'll see, but you're right, it's confusing.
So there's the.
So a local electoral board is an ad hoc convening of a board that's going to be the arbiter of an objection to candidate nomination papers. And it's 3 people. And it's the mayor and the clerk and the longest name member. So that's the board. The election authority does election administration. And so in DuPage County, that's the DuPage County Election Commission. In Cook County, that's David Orr's office. In Chicago, that's going to be the election commissioners. Does that make sense?
Having been through a signature challenge, I can add a little bit.
Not as a candidate, but
As a candidate. And they were on the county level. It's not a book. They do it on a computer. You have a low-level county employee. You sit there, or some rep for you sits there. Someone from their campaign sits there, and it's a low-level rep at the county level that decides whether it matches. Now, before that, correct me if I'm wrong, they have to identify, if I recall, they identify each signature that they're going to challenge. You could go to those people and get, I think it has to be affidavits, and they have to be. I think there's a process there. It's long if you went to each one. But in an election like this, where you only need so many signatures, and if they're going to try and challenge your signatures, you know you got these from genuine people here. You can go knock on their door and get them to sign that.
And they sign an affidavit that says that. I've traveled around doing that, and it's a really long process.
Well, the clerk, the election authority is not going to check signatures.
Not the candidate.
Oh, the candidate.
Candidate.
So it's only, so the nominating papers and the signatures are considered all valid, everything's great, unless someone comes forward and says, I object, and they put forward
But
their valid.
they have to identify which signatures are challenged.
Yeah, they have to be very
So you know
specific.
ahead of time.
Right, they have to be very specific and identify and articulate why a certain signature is invalid and have
They don't have to
forward their
articulate.
explanation.
That makes it sound like there's actually some work done. They could just shotgun and say this and then just give a reason, a random reason. It's called shotgun challenging. Just an X next to it and say not valid or wrong address, just to make you have to work and spend money.
And then you have to rehabilitate the signatures.
Right.
Signatures.
Okay.
So some of the problems that people have with signatures is, as we talked about, the putting it in pencil, not signing, someone not using their right address if someone's moved and they haven't re-registered.
Well, let's talk a little bit more about the format stuff.
Okay.
So for example, we were talking about how the sheets all should be the same size and look and conform to one another, the signature sheets. When you file the sheets, they all have to be signed simultaneously. They all have to be filed simultaneously. So don't submit some signature sheets and thinking that you can add to your total later. So wait until you have all of your signature sheets collected. Also, there's a condition, a requirement that your nominating papers are securely fastened, and that means no paper clips because that's not secure. A binder clip is generally not considered secure either. You're going to want to go and make sure that it's fastened, that the Kinko's, or I guess Kinko's doesn't exist anymore, but something that is like Kinko's of yesteryear. And we talked about pagination. So I think those are all the formatting issues that you should be aware of. So now we can actually move to more like signature issues.
Right, just one question on the faceting.
Yes.
Just a good solid staple in the upper left-hand corner, or should you run staples down the side?
On the top.
I would have it bound. I mean, I don't know. Like, I mean, even if it's like you do a 3-hole puncher and then you get those
They give
little
you the 2 holes.
doodads.
They give you the X's where the 2 holes should be. It's not an easy to find binder.
Yeah.
Like an election lawyer has a bunch of those binders in their office, but no one else does. You can't buy them at Staples. You can order them online.
Amazon maybe?
Yeah, it's a 2-top binder, which is not. School reports are submitted on a 2-top binder.
I mean, that's not the only acceptable
That's the
form of
preferred
binder.
with the actual X,
Right.
bind here. You could put 2 staples there because you don't need that many sheets, though, to answer Steve's question.
I mean, I think that it depends on, I think that like, there's been court cases where it was a 2-page signature sheet or something like, it was something really simple and it was stapled, and there was an objection to it, and the court said, well, in this situation, that sufficed. So it's also context-based. So some of this is, I mean, some of the, there's sometimes no hard and fast rules because it's very fact-intensive inquiries when you're looking at these kinds of challenges. It's all about the facts. So it's the evidence in the record, and comparing the record to the voter registration records. So yeah.
Do you want to?
I know that you've been told that it's really bad to collect, like bad signatures are often collected at L stops or in front of grocery stores or trains or places where people are from a lot of different communities are congregating. So the chances that they're a registered voter in your district at whatever government body that you're running for are slimmer. So a lot of bad signatures come out of those kinds of situations. I've heard that really the best way to do it is to canvass your neighborhood and go door to door, collect signatures that way, and introduce yourself to
Or stand outside of the last election.
your constituents.
Or you can look up your neighbors ahead of time and see who are the registered
Right.
voters
And
in
go
your
only to
neighborhood
those,
and
and only go to those houses. So be really targeted about where you're going to collect the signatures.
And we always recommend getting at least 3 times more signatures than are required, unless there's a statutory limit, upper limit on how many
How do you
signatures.
know if there's a statutory limit? Is that certain?
It's very dependent on different municipalities and different requirements. So if you do have a specific question, you can call me, or I call David Orzoff. I call the county clerk, because it's very specific based on the last gubernatorial election and how many people voted.
In our town, it's based on the last mayoral election.
Right, it's equal to at least 1% of the total vote cast for mayor at the last preceding mayoral election. So you need to find out how many people cast vote. I think it was 2011 would have been your last. And I looked today and it was like a 17% voter turnout. So that's probably a pretty low number. But I would check all of those numbers and I would call and verify.
You need to know what were the number of registered voters who voted. That 17% number reflects the number of registered voters who voted, but you need to know how many registered voters there were at the beginning to figure out the number.
So calling her would probably be the best option to do that.
So yeah, call the election authority because they should give you the right information. They're supposed to. I know that. I've heard stories about some election authorities not being very forthcoming, but I say this squeaky wheel has to grease. Ask multiple people, make sure that the information they give you conforms with one another. Actually, we talked a little bit, Andrea was talking about handwriting and printed versus signature, so we don't need to talk about that. We talked about paid circulators, but obviously, like the better you know the circulator, then the more you can trust that circulator is going to do a good job, as opposed to round tabling, sitting up with their friends and forging signatures attached to residences.
If you're looking at other people's ballots and you're looking for common errors, another error is if you see addresses that go 123 North Avenue, 124 North Avenue, 125 North Avenue, 126 North Avenue, because addresses don't actually work like that. It goes 1, 2, 123 North Avenue, 125 North Avenue, so that's something to be aware of when you're looking at other petitions too.
Oh, right.
And your circulators petitions,
Right.
because you want to make sure your circulators did a good job. So it didn't just forge or have a bunch of different people have a signing party.
Yeah, chances are people are going to stay on one side of the street rather than bounce back and forth. So that's a giveaway sometimes. That tips people off that perhaps there might be something wrong with the signature sheets. Liquid paper is another thing that tips an objector off that there might be some kind of funny business on the signature sheet. Yeah. Are there any other questions about signatures? Yeah.
It has to do with signature, but also the actual circulating sheet. If you have a sheet that you've made up that has the town, the village, and the Cook County, and Illinois, and somebody as they're writing their address, writes their address, and also gives the name of the town, that wouldn't be a reason for an objection, would it?
As he said, anything can really be a reason for an objection.
Sure.
Is that a reason a signature would be thrown out? Is probably a different story. And a signature needs to be, we can talk a little bit about why signatures are thrown out. If it's clearly not someone's signature, they don't keep records of decisions in the local electoral boards. So what happened 4 years ago in Forest Park may not actually give you insight, even though some of you were there, to what may happen this upcoming year if there are any challenges. So there's not really any history to go off of, and it's really the decision of the three people there. And we'll talk about the appeals of those decisions in a little bit. But they'll look at the sheet. I was in DuPage County last year when they did this. They look at the sheet. The objector states, usually it's a person that's not even there, in my experience. There's an attorney there, and then the candidate will be there, and his or her attorney. And they will look at the signature. They'll go around and all kind of look at it and say, good, bad. They say they have training in handwriting. Are the loops okay? Does something look different? And they look at it pretty objectively and decide that's a good signature, that's a bad signature. If you have one bad signature, that does not mean your entire sheet is thrown out. That signature is thrown out. And they'll go through signature by signature.
Yes, the local electoral board members are the ones who are going to the arbiters when there's a challenge before them. And so they'll check to see which objections are valid and which ones are not sustained.
And they would follow the exact same rules relative to throwing out a sheet, or if it was one signature. There are guidelines that say that, correct? So that if it's a local group doing it, they can't say if there's like two signatures that are questionable and they say are not, that we're going to throw out the two signatures. The local group can't say, well, then the sheet goes thrown out.
No.
Well, they can say that, but that's not a true. It's not reality. Like it's not. They can say it if they want. The local electoral board can't throw that sheet out. If they do, if there's a challenge in court, they would probably be reprimanded, and hopefully, the court procedure would have time to get the person on the ballot.
The local electoral board has that decision making. Are you saying that they throw it out, the entire sheet out?
I'm not saying I have that experience. I'm saying that if they did, they wouldn't typically do it because they're guided by certain rules too. But if they did, you'd have to take it to the I don't think it's something.
Yeah. So the local electoral board is considered like a hearing of an administrative body. Basically, it's quasi-judicial. So the rules of evidence apply. So a candidate who's defending their nomination papers and their objections will want to make sure that the record is full. Like if they have objections to any of the candidates, any of the objectors or specific objections, they'll want to state that on the record because all of that information is what the circuit court is going to look at in making its decision should someone take it to the next level, the candidate take it to the next level to get back onto the ballot. So it's really important to, even though it's not like a proper court hearing, to kind of think about making sure that all your objections are made on the record and any defense you have against against the accusation that a signature is invalid, that you state all of your defenses on the record, so it's preserved.
Do you have anything else?
No.
So, yes.
Under technical objections, the last item says failure to file form officially deleting signatures. I could see a circulator inadvertently have somebody sign that was not a registered voter. How do they deal with that?
If the signatures are presumed to be valid unless challenged. So unless
but let's say you know, someone signed it, and then after they signed it, they said, "Yeah, but I'm not living there anymore."
Okay.
Or say, let's say that. Okay, no, you've deleted that.
Mm-hmm.
By just crossing it out, is that correct?
Yes.
You don't have to do anything more than what does this? What
Okay,
does that item mean?
So failure to file form officially deleting signatures, that's only the candidate's authority. So we weren't very specific here. Sorry about that.
Okay.
So the only person that can officially delete signatures
Would be the candidate.
is the candidate. So if the candidate, candidate's allowed to.
Okay,
So
that's
is the
all
candidate
I
allowed
Yes.
to scratch signatures? So candidate's allowed to delete signatures, but unlike the circulator,
Who it's done.
the candidate has to file this form of officially deleting signatures.
I see.
Yeah. Sorry
Only-
about that. Thanks for the good question.
Only if the candidate deleted it or if the circulator deleted it?
No, I'm pretty sure, I mean, we can double check on that,
Yeah.
but I'm pretty sure it's
The
only
circulator.
in the condition where it's the candidate that's deleting.
I'm pretty sure about that too, but we
So
can
this
check.
is, so the circulator comes in and they get their petitions in and they're notarized and everything else. And the candidate says, wait a minute, I know
Yes.
this guy moved, so I'm gonna take it out.
Right.
Then he has to get the file, the form, right?
Yes.
Okay. Well, what if the candidate's the circulator?
It's always,
Then before it's notarized, I think it has to do with the notary process technically, because when it's notarized, you're attesting that everything there is true and accurate to your belief. So if after it's notarized, you make changes, the new form, the failure to form, is also then, I believe, notarized. So you're attesting again to the truth of everything you're submitting. Does that make sense?
Yeah.
Okay. Along with these other common objections that we should probably go over, wrong or missing election date. Make sure you have the correct election date on there. Actually, I had someone do a petition and something like that was missing. So just make sure that, I know it's little, but you get excited about things. Unclear statement of the office sought. Make sure it's clear. Failure to designate the right type of election. April 7th consolidated election.
You know, that just put a big reminder in my head. That happened because they didn't say like village of, right? Somebody here I know remember village, just saying, you know, Forest Park or Oak Park, it's village of this, town of. So it really is the technical name of where you live. I know it sounds crazy.
name.
Yes.
Right. The what, Miriam?
Like the incorporated name of the entity. And I know that it's probably a better idea to have it spelled out village as opposed to, but although if defended, if the person defending it says that this is a abbreviation that's commonly used, that'll probably survive the defense. But why even go there? Like, to avoid it from the get-go, just spell out village, for example, and spell out those terms so that you don't get the impression.
So a lot of those little things that you see, you think aren't that important, or it's okay, I missed the page, those are actually really important. We work with someone who all the time says, this is a candidate's first time they get to introduce themselves. I want to make sure my candidates can cross their T's and dot their I's. So it's very important that these forms are uniform and follow all those exact rules. And someone looked like they had a question, and I don't know which way it was.
Getting to the statement of economic interest, Does DNA does not apply? Is that okay to put down there as an abbreviation if it doesn't apply to you?
I would write it that it doesn't apply to statement because you still have to fill out the statement even if you do not have to file your.
I mean, you might not have anything to disclose. You still, and so yeah, you could say not applicable or I don't know, DNA. I've never heard that before, but I've heard not /AN/A. So I guess if the reader understands your abbreviation, you're good to go. But yeah, you might not have any financial conflicts to. You might not have anything to divulge.
Any other questions with that?
Have you ever seen a statement of economic interest challenged as far as like, I know this person has some kind of dealings with, you've never seen it? I've never seen it.
I haven't seen it.
No, not at the time of the filing. I mean, later on, I've heard people grumble about that, the filings that they went to check after the fact weren't accurate. But not at the time. I mean, usually the objections relate to they failed to file the receipt as part of their nomination papers, or they didn't file the electronic income statement in the right office, and they should have filed it in a different office. I mean, things like that. I've never seen anyone challenge the content.
But for people here, I believe we do that at Maybrook. You can get that paperwork, right?
That's the other thing.
But I think that's probably something they can bring up at the, if one is objecting to someone else's candidacy on several bases, I suppose that's one basis that could be brought up, that they fail to divulge true conflicts of interests as defined by the law that governs these economic interest statements. But one of the problems with our economic interest statements in Illinois is they're kind of weak, unfortunately. So we need that to change. So we need that legislative change to make them stronger.
So after you go through the electoral board hearing, if you don't like the outcome or the objector doesn't like the outcome, there's 5 days after the decision of the electoral board that the candidate or the objector can file a petition for judicial review with the circuit court. And then those court hearings are to be held within 30 days after the filing of the decision of the petition, and a decision should be delivered promptly because they need to get the ballots printed, I think is a lot of the timeline with that. And with that, usually, I think most candidates will have hired an attorney, if not all, and they review, as Maryam was saying earlier, the record based on the record. So the objections that were brought up, and they're not going, they're not going to be sitting there and going over everything except what's already on that record. So it's very important to preserve your objections, to make sure that you state the signatures valid, or the sheets valid, or these sheets are have the proper headings on them.
What was I going to say?
Did you go to the circuit court with your?
Did I go to the circuit court? I won at the county level.
You don't want at the county level?
Oh yeah, because you were running for a county office. So yeah, the county board, there's a county, I think I forgot to mention the county electoral board too, so the counties have their own electoral boards. I was going to say that the electoral board hearing is an open meeting. So you can videotape it, any member of the public can videotape an open meeting of a public body, and the local electoral board considered an ad hoc public body that's only resurrected because an objection was filed. So, in a small election, you should probably, if somebody were to be challenged, we have resources at our office that you could come by our office and check how you might be able to defend against some of the challenges to your signatures, for example. There probably are resources, maybe even online, that might be able to guide you, but we have a library of sorts. So that's one resource for members of the community. But generally speaking, also with your petitions, one thing that CAC routinely does is assist people with just making sure that their petitions have the requisite information, so we can do a double check for people. And especially for referendum questions, people often want to run by the language of the referendum question, which there's no magic formula for getting it right, but there are some simple rules that can be implemented to make sure that the referendum question would survive a challenge more likely than not. One thing that you probably don't know about is like ballot position issues. So I know people who run for candidacy sometimes care about ballot position issues. And I think it's usually the first come, first serve. So whoever files their nomination papers first. So sometimes you'll see lined up on the first day of the date to file their nomination papers if there's a line formed already, because the first person, there's this feeling, or maybe it's been scientifically tested, I don't know, that the person who's listed first on the ballot gets more attention just by virtue of the placement on the ballot. So that's why it's something that people pay attention to. Candidates like to pay attention to that.
But it's important to know if everybody's in line at the time it's open, you're all considered filing simultaneously, and then a lottery is done to figure out who will be first on the ballot within 9 days of the last day of petition filing. And then some people don't want to file right away because they don't want to disclose their candidacy, and that gives people less time to look at the paperwork and file objections to the petitions. So there's a way that you can consider with both.
So it's not, I'm sorry.
Yes, you're fine.
So it's not the election, the local group is the election
Electoral
board. They do not determine, if everybody's in line together, they do not determine the position. It's done by a lottery or something.
If everyone is in line at 9 a.m. when it opens, it's done by a lottery to determine the ballot order.
Who does the lottery?
The election authority. One thing that's important to know,
Not the local.
one thing that, not to jump back to the other kinds of confusing names, but the local electoral board, like they can only be the arbitrator of the objections that come before them. They can't make up their own objections and say, oh, hey, objector, you forgot a few. Let me add some to your list. That's a no-no. They're not allowed to do that. So yeah, they're just not allowed to participate in that process of identifying potential objections.
A few other things with file.
As far as ballot position, what happens if two people want to be last?
I don't think that's happened, but I would assume the way last is determined normally is the last person to file. So I guess if you're there at 4:59 and there's two people in line, they'd probably be doing the lottery too.
Tony likes to go last.
A few other
Well,
things.
that might be a strategic move if someone waits until the last minute to put in their nomination papers.
Because upon filing the papers, they are considered open for inspection, and then the timeline to file objections to the papers.
So it's like a balancing test. Like, do you want to be first on the ballot, or do you want to leave less time for people to review your papers?
So they're open for review as soon as they're filed.
The petitions are available to the public upon their filing with the proper office and at the earliest convenience of the office.
So if you want to look at the petitions, you can ask them for a copy, yes? You just have to pay
Yes.
for it, and then that gives
Yes.
you the opportunity to go check signatures or whatever.
Exactly.
I'm sorry, Chris?
And the earliest convenience will be a business day or two, not next week.
My God.
Yes, it would be. It should allow you the time to properly.
So, like, I guess if someone files their nomination papers last minute on a Friday, and someone wants to review them on Saturday, that's not at the earliest convenience.
but
Monday.
So Monday.
Another note, candidates can file more than one set of petitions for more than one office, but upon notice from the filing office, the candidate must make a selection in writing which one that they'll be, or you can file 2 sets of petitions for the same office, but then upon filing you have to say, these are my valid petitions, these are my bad petitions, I don't want to use those. You can also have someone else file for you. You don't actually have to be the person to file your petitions. There are no statutory requirements regarding a time element for mailing petitions. However, all petitions that are received by the office prior to the first day of the filing period will be returned to the sender, and petitions received after the end of the filing period, regardless of the postmark, will not be accepted. So I would err on filing in person to assure receipt, proper receipt.
Why would someone file 2 sets of petitions in a 5-day
They may have
period?
had, I don't know, if they didn't know if they could be there in time or something, and a friend did it.
Okay.
There may be something like that. A candidate may file for more than one office, but must withdraw from all but one office within 5 business days following the last day of petition filing if the offices are incompatible. If he does not withdraw or she does not withdraw from all but an incompatible office, the name will not be certified.
So I think an answer to your question, because I've never seen this happen, but let's pretend, and hypothetically, if someone who's collecting a few signatures, like not that many signatures, 50, 100, let's say they submit their signature, their petition, their nomination papers, and they realize, oh no, I made a mistake, because you can't go back, you can't change your nomination papers once you've given it off to the clerk. Like now it's hands off. Like you can't add sheets to your petition. You're not going to be able to go and be like, oh, can I like write village to VILL dot? Like you're not going to be able to do anything to change your nomination papers. So let's say you get your act together and you redo your nomination papers and you collect new signatures, and then you go file another set of petition for that same office. So I think what Andrea is saying is that the office is going to contact you and say, we got 2 petitions from you, what's going on? And then you say, no, disregard the first set. And if you don't respond and say disregard the first set, then they're going to take the first set. That's what it sounds like to me, based on the laws. I've never heard of that happening, but maybe it did, and that's why it's in the rules. The rules usually are trying to solve some problem that happens, or to like prevent a problem from happening.
Can you explain that? You go to 2 different offices.
And they're incompatible.
You have to withdraw within, what,
5 business days from the last filing date.
In writing.
In writing.
So if he does not withdraw from one of the incompatible offices, then the name will not be certified.
In either.
In either.
So incompatible might be mayor and commissioner,
Yes.
not mayor and school board member.
That it really depends on the local authority. In DuPage County,
Well, I know there's a few attorney general opinions on what offices are incompatible, but it's not fully defined, like what offices are incompatible. Like when we had a couple of candidates recently who were mayors of municipalities and they wanted to run for county office, and they said, we're going to keep both offices. It was 2 different mayors at the same election, same county election. They said that if they were to win the county board, that they would be both mayor of the municipality and the county board, and petitions were circulated by citizens who because they were trying to get an advisory opinion about the incompatibility there, but in the end, the citizens, in the one case, in the municipal case, the citizens collected signatures for a referendum on the ballot stating to change the rules, saying that like no one in that municipality can serve another elected board. And the county, the actual county board members decided to put on the referendum, on the ballot for the county, that same question, that someone who serves on the county board can't serve in another elected official capacity. So that's a case in which they would be incompatible, where there's an ordinance passed by the county board of the municipality. There's a few defined cases by the Attorney General.
But a commissioner and the mayoral candidate obviously
Yeah.
wouldn't work within Forest Park. What questions do people have in the remaining time? Do you want to talk to us individually too?
We have
You're
like
welcome.
15 minutes.
Yeah.
So I know we went through a lot of information
Yes.
really quickly.
Maybe very briefly, referendums, and specifically referendums dealing with the form of government. How, I know it's probably late, but there's been a lot of talk in our town about getting rid of this commission form of government.
So the kind of referendum that you mentioned is one of the few binding referenda authority that the public has. So in Illinois, Illinoisans have the direct democracy option of changing the structure or form of government. And all of that's defined in the statutes, like what iterations you can switch to and what the language of the referendum has to be like.
Okay.
So
It's pretty specific.
It's really specific.
And the
Okay.
signature requirements, I think it's 10%.
I think the
It's
signature
pretty- it's
requirements are
higher,
larger than the
a much higher, I think it's 10%. Signature requirements, but if you contact us individually, we can let you know that because the wording is very specific.
Okay.
Yes.
If we petitioned to get a binding referendum for changing the government, can the council bump us by, they still can, even though it's our one opportunity?
Yeah, unfortunately.
Can you
the
maybe
rule-
explain that to everybody?
Sure. So there's
Yeah.
the rule of 3 in Illinois, which means there can only be 3 referendum questions for each level of government, school district, state. And the municipality in this situation has the authority to put 3 binding questions on the referendum, and their language is presumed valid. So they could come up with 3 questions and put it on there, and then even if you filed first, their questions would take precedent.
So that happened in Chicago recently, when in Chicago there were folks that wanted to put an advisory question on a city ballot about how Chicago Public School District should they be elected officials as opposed to appointed officials. And one of the aldermen decided that he didn't want that. I mean, this is like the background information, but he in order to get rid of that referendum question, advisory, mind you, not binding, he initiated 3 other referenda that are on the ballot.
In the recent election, it was said that the minimum wage question, and I can't remember the other questions, were questions that were put on the ballot.
And
So a lot of
those
questions.
superseded the initial one.
Yeah.
So the only exceptions to that are you can have as many questions for constitutional amendment changes. So like any referendum questions for constitution, like you can have as many of those as you want. There's no limit of 3.
Okay. Hypothetical. You can get that type of referendum on each election, so every 2 years.
Yeah.
And what if there was this? Well, never mind. I know the answer.
I mean, you can't
What if it
utilize the
was
same
chronic?
signatures
What
from
if
one
it was like
that
6
get
years or
collective
3
signatures.
elections in a row where a village deployed 3 of their own questions? And
So
that
you
was
could go to the
lawsuit.
legislature and try to institute change for more
It would be a
friendly.
legislative solution?
Mhm.
Okay.
Well, but can you file, there's what the deadline is, whatever, January or something like that. Could you be filed on the last day? Can they decide after this filing date that they want to put something in
I think their
referendum?
filing date, I have it on there, I don't remember, I think their filing date is actually later than the public. Yes, the public has to file by January 5th, and then January 20th is for the governing body. So, it'll be a legislative change.
Can't you guys fix this?
So basically for referenda, everything we talked about applies. The only difference with the referenda is the questions must be, well, in the case of a binding referendum, you've got to adhere to whatever the legislation says. You've got to, So, for example, for home rule status, that's a binding referendum that a town could seek to cease home rule status. And that's how you have to phrase it. Like, shall we cease home rule status? And the answer to that would have to be yes, which sounds weird because you're saying no to home rule. You're saying yes to ceasing home rule, but the legislation is really specific about how the question has to be worded. But when it comes to advisory referendum, really the only rules that apply are that it should be a simple sentence, non-compound, and it has to be in the form of a question. Sorry, not a sentence, in the form of a question, and it has to be answered by a simple yes or no.
So the simpler, the better. I had someone last year come to me with a red light question, and it was like 3 sentences and compounds.
So one of the things, so that's
very simple.
Yes. So like the term limit question, one of the reason why that got thrown out of court is because you could have said yes to some parts of it and no to other parts of it. It didn't work together as a unified whole where the parts were interdependent. But because the campaign was trying to get at both the structural and what's the other one? I always forget.
It's procedural, structural and procedural.
Yeah, the structural and procedural aspects, which is the only way that you can get a constitutional amendment on our ballot to change an aspect of the legislation is if you get to the structural and procedural changes to the legislature. So the term limits folks were trying to do both of those, but it was all disjointed.
And then all of the same rules about heading, size, page numbers, signatures are required for ballot, for referendum questions.
So like when you're numbering the pages, if you forget, like if you go 1, 2, 4, 5, 6, and you forget to put 3, for example, or something like that, that's a basis for objection. The chances that you're going to survive that are probably strong because it looks like just like a little clerical mistake. And, what would be a little bit more alarming would be if you have several sheets that look alike because they're all, they're Xeroxed.
Or you see signatures that are the same. And
yeah. So, it's always good to just be very mindful of all of these little requirements and have your checklist next to you and go through your checklist of did I pay attention to this really important feature of my nominating papers and did I pay attention to that? And this can be a guideline for this thing. This outline can help guide you. But a lot of you who are circulating your papers now, at this point, yeah, you couldn't like in the middle of circulating signature sheets, you wouldn't want to change your sheets unless you're ready to dump all your old sheets. Because all of your sheets need to conform with one another.
Can a candidate or the circulator or whoever make any kind of clerical notations on the sheet? Let's say that they number it, but then they put some other mark on there. Would that be grounds for?
I would stay away from string marks. I'm not sure how they're treated, to be honest with you. As long as so all of these rules, the purpose of all of these rules are to prevent fraud, and it's supposed to preserve the integrity of our election system, and we're supposed to feel safe in knowing that the candidates that we're going to print on our ballots have some modicum of support from the community, and we're not wasting our ink. So generally speaking, if the answer to your question is this kind of a mistake is not evidence, would not be an piece of evidence for fraud, then chances are it's not a valid kind of an objection.
But that doesn't mean there can't be an objection for that.
Right.
And objections can be very expensive, the objection process,
yes.
Especially if you go to court. And it also delays the process of making sure that you're on the ballot. So it's best to try to avoid that.
Right. So best practices would be no string marks on the sheet.
So you want to go into that answer first?
And the signatures and the petition sheets?
You have to have that, there's a statement, and it's usually given when you get your sheets or the example sheet that says it wasn't circulated more than 90 days in advance.
Yeah,
and then the notary has the date on there.
So that's the circulator's affidavit. So we talked about the different pieces there where they swear to being 18 years of age and U.S. citizen, which are the two requirements to be a circulator. So you don't have to be a resident of the state. You don't even have to be a registered voter. Just 18 and a U.S. citizen.
How is your organization funded?
Oh, thanks for asking. We're a nonprofit, so we're entirely funded by individual contributions from everybody who values our services, and also through foundation grants. So we've stayed away from any kind of government funding to maintain our independence, which really kind of narrows our funding resources. But recently, we've made a more strategic decision to seek corporate funding, like for law firm donations. So we've also stayed away from that kind of funding, thinking that that would really keep our organization on the straight and narrow path even more. But we came to the conclusion that to survive, we need to open up our funding sources. So individual contributions, grants from foundations, and corporate foundations and donations.
You're doing a good service.
Thank you so much. And you all are doing a really good service too, because you all care to participate in your local communities and even take a gander at running for office or thinking about running for office. So
or helping other people.
Yeah, so I applaud all of you.
And we have been in DuPage, we've been in Elmhurst for 20 years. We just celebrated our 20th anniversary. So
Yeah. Yeah.
We're a small office, but
yeah, we are a small office, and it's only been in recent years that we've been getting more of these inquiries around election time, and I think maybe there's been more objections to some of the questions and candidates that are being submitted to the election authorities, and so people are seeking to prevent the objections from happening. So we've been doing more of these kinds of presentations, and we always welcome people to contact us for our free services. We do one-on-one community lawyering services where we offer legal services for people who want to participate in the government process and they're somehow being kept from participating. Whether their First Amendment rights are being violated, whether they're not being allowed into an open meeting, or the door is locked, or all the seats are removed from the meeting.
or there's only 5 seats at the meeting. But we do a lot with the Open Meetings Act and the Freedom of Information Act too, so if you have any questions with that, a lot of our work is based on that and civic education.
Yeah, we also work with journalists and public officials and students and educators, and it's all around civic education and public participation.
Good. Keep democracy alive.
Yes, thank you.
Are there any final questions, or you said you might stay for a few minutes?
We'll stay for a few minutes.
We're not getting kicked out for another 5 minutes.
Okay.
8:45 is the midnight hour around
9 o'clock.
Okay. All right.
The video going
so we'll
on
turn into
still?
pumpkins.
Oh, well, I'll go ahead and close the meeting then. First of all, thank you for
You're
coming
welcome.
out.
Thank you for having us.
And the board members, myself, Stephen Backman, Gloria Backman, and Sharon Daly would like to present you with a gift from one of our hometown candy stores. It's the one that we frequent as often as we can. La Maison de Bonbon. It's over
Oh, you're so kind.
Thank you so much.
You're the kind ones for coming out.
Oh,
today.
no.
Thank you very
That's what we're
much.
here for.
Oh, yeah.
So, yeah. So call us anytime, Steve. You know what this is what we do.
How about a final big hand?